WIPO Master Class on Intellectual Property Adjudication, being organized by the High Court of Delhi in collaboration with the World Intellectual Property Organization. On behalf of the High Court of Delhi, we extend a special welcome to our Chief Guest, Honorable Justice Sanjeev Khanna, Judge Supreme Court of India, whose gracious presence here today is a testament to the importance of intellectual property adjudication in the legal landscape of India and the world. Our warmest welcome to all the distinguished invitees and dignitaries present. The lighting of the ceremonial lamp symbolizes a blessed beginning. Symbolically, just as light dispels darkness, knowledge dispels ignorance. Thus, salutations to the lamp. I request our Chief Guest, Honorable Justice Sanjeev Khanna, to kindly come forward for lighting of the lamp, sir. I request the dignitaries on the dais to kindly join in the lighting of the lamp, please. I request Mr. Manmohan, Honorable the Acting Chief Justice, High Court of Delhi, to felicitate and express our deepest gratitude to our Chief Guest, Honorable Justice Sanjeev Khanna, for gracing the occasion with his encouraging presence by presenting him a potted plant. I request Honorable Justice Sanjeev Narula to felicitate Mr. Manmohan, Honorable the Acting Chief Justice, by presenting him a potted plant. I request Honorable Justice Sachin Datta to welcome Mr. Kumaran, Special Secretary, Ministry of External Affairs, Government of India, by presenting him a potted plant. I request Honorable Justice Shailendra Kaur to welcome Ms. Yunju, Director, WIPO Judicial Institute, by presenting her a potted plant. The 2024 Masterclass on Intellectual Property Adjudication symbolizes our commitment to deepen our understanding of the practice and principles of intellectual property adjudication across diverse jurisdictions and to facilitate an ongoing learning and exchange of ideas in this field. May I now request Honorable Justice Pratibha M. Singh, Judge High Court of Delhi, to kindly deliver the opening address.
Very, very good morning to all of you. Before Justice Manmohan, our Acting Chief Justice, gives the welcome address, just to place the context of this masterclass, these are some opening remarks. As you all may know, the World Intellectual Property Organization is an agency of the United Nations. It is the overarching body in the world for looking after intellectual property. There are various divisions within the World Intellectual Property Organization which deals with aspects concerning intellectual property, such as negotiation of treaties, such as monitoring and running the Patent Cooperation Treaty applications, organizing worldwide seminars, increasing sharing of views between countries, organizing training sessions, and various such events. But one of the recently constituted events and divisions of the WIPO is the World IPO Judicial Institute. This Judicial Institute fosters dialogue between judges from various jurisdictions, and on an annual basis they hold a judicial colloquium sometime in November, October, November, where more than 500 judges participate every year, both virtually and physically in Geneva. And one of the smaller, intense programs of this Judicial Institute is the World IPO Masterclass. So this is the 4th edition of the WIPO Masterclass, which on behalf of the Delhi High Court, we are all very, very happy to host today and over the next 3 days. The previous editions of the WIPO Masterclass have been held in Washington, D.C., in Beijing, and in Munich last year, which I had the opportunity to attend. The WIPO Judicial Institute has fostered various friendships amongst judges, and we are able to discuss in detail and thrash out various issues concerning intellectual property enforcement and adjudication. It is an amazing forum where we are able to see that one message that I felt we always learned was judges in every country continue to be serving their own societies and countries while sharing their experiences with us. The present masterclass was a conception of Yunju last year in Munich, and she asked if the Delhi High Court, which comes out with so many IP decisions on an annual basis, would be happy to host it. So at that time, Justice Satish Chandra Sharma was our Chief Justice, and I went to the Chief Justice and he gracefully accepted that the WIPO Masterclass can be hosted here. This was followed by a visit by Mr. Darren Tang, the Director General, with his entire delegation. So he's come, he's seen our High Court, he's met with all our wonderful judges who are here to welcome you all today. And it's been a great pleasure to organize this on behalf of the Delhi High Court. Our dynamic and kind Justice Manmohan, who is the Acting Chief Justice of our court, has given us his leadership, along with the IP Division Committee, whose members are all here today. And I really think that this is going to be a forum where the Indian courts, which are also represented from Bombay, Madras, Calcutta, and Ahmedabad, as also the Delhi High Court, welcome you with open arms. And we really hope to continue this dialogue, enjoy the experience of sharing our experiences and judicial precedents in intellectual property, and have long-term relationship with various countries, which are over 20 countries which are represented here, with 36 participants. And you know, the 2021 was a watershed moment in India for intellectual property, in a good way and in a bad way, because the IPAB got abolished and the IP divisions of various courts have been set up or in the pipeline. And we really think that with the amount of intellectual property being registered in India in terms of trademarks and patents, India is going to see in the next decade or so a huge influx of intellectual property cases, which of course the data we will be presenting to you during the course of the sessions today and tomorrow. One thing I would like to acknowledge is the strong support by the Ministry of External Affairs. Dr. Jaishankar himself has given a video message. He really wanted to be here with all of us, but on behalf of the Ministry of External Affairs and the government, we have Mr. Kumaran here today. Justice Khanna is, of course, our own Justice Khanna, who is here to be with us and to say his words today. With these opening remarks, I stop here for the time being, and Justice Manmohan will now give the welcome address today.
Thank you, ma'am, for setting the tone of the conference. I now request Honorable Justice Manmohan, Honorable the Acting Chief Justice, to kindly deliver the welcome address.
Respected Justice Khanna, Ms. Unjo Min, brother and sister judges from all over the world, Mr. Kumaran, Justice Pratibha Singh, Justice Naveen Chawla, my brother and sister judges, distinguished ladies and gentlemen, a very good morning to all of you. I extend a warm welcome to Honorable Mr. Justice Sanjeev Khanna, who has kindly agreed to grace the occasion, and that too on a working day in the morning. Sir, your presence means a lot to us. I extend a warm welcome to Ms. Unjo Min and brother and sister judges from 21 jurisdictions who have traveled long distances to be with us. In India, we believe in Atithi Devo Bhava, guest is God, and we welcome you in the same spirit. I also welcome my brother and sister judges as well as those who have traveled from other cities and other states. I extend a hearty welcome to Mr. Kumaran, Special Secretary, MEA. I would like to thank you on behalf of the High Court for all the cooperation that the MEA has extended in organizing this event. Designed a few centuries ago to meet the simpler needs of an industrial area, there is no other field like the intellectual property that has responded to changing technologies by morphing into a completely new being. Earlier, the proverbial IP infringer operated from an offline establishment which was within the reach of the respective courts. With the rapid advancement of science and technology, transactions across borders are concluded at the click of a button, and the infringer's identity and location remains unknown. Thanks to the digital revolution, national boundaries have ceased to have any relevance in the commercial world. The core concept that IP laws are territorial is under serious strain. Let me illustrate the point by referring to the case of the entertainment industry. Our motion picture industry is huge, with more than one movie releasing every Friday. How do we deal with online piracy ecosystem where the source of infringement, namely the server, is based abroad? The other issue is that if you block one website, two more alphanumeric websites prop up. Indian courts, in particularly Delhi High Court, realized that we cannot wait for legislation which deals with online infringement or piracy. We also decided that narrow questions of jurisdiction can't come in the way of substantive justice. So, adopting the best practices prevalent in the world by exercising jurisdiction on the basis of availability of the content, we devised a concept of dynamic injunction, wherein we created an island by issuing an injunction to our ministry to direct all service providers to block websites in India which primarily indulged in piracy, including their alphanumeric variations. However, even solutions like these can be mere drops in the ocean, as infringing content continues to be available in other jurisdictions. Unless we devise a system of global injunctions or global cooperation, the violation of copyright and the proliferation of piracy will not be matched by the solutions emerging from individual courtrooms. Sometimes we are faced with the questions of balancing competing rights where actors are not painted in obvious shades of black and white. A good example of this is matters involving enforcement of standard essential patents, or SEPs. In March 2023, this court had the occasion to decide 2 cross appeals and lay down certain foundational principles governing SEP litigations. We ruled that when an implementer is found to be voluntarily negotiating the renewal of a license that it held for some time, we said it was a fair assumption to make at the prima facie stage that it considered the patent both valid and essential. We thus ruled that a pro tem deposit of the same value that it was paying earlier was an equitable interim arrangement. While determining the FRAND rate for India in this dispute, the issue we foresaw arising in future litigations is whether a determination by one court in one jurisdiction of a global FRAND rate ought to be the benchmark for other courts where similar issues are being litigated, or whether each court should come to an independent determination of the FRAND rate. And what happens when proceedings to determine the FRAND rate are started in, say, China, while patent infringement proceedings have started in India? Which court is then to determine the FRAND rate, and how will it be implemented in other proceedings? Further, what will be the impact of European Commission's proposal for a new regulation for SEPs? If passed, will the European Union's essentiality checks have persuasive value? These are important questions that are integral to cross-border litigations in our changing times. As multi-jurisdictional litigation grows, so does our interdependency. There is thus great value in hearing perspectives from different jurisdictions that help each one of us as judges calibrate our own understanding of some incredibly complex subjects and learn from each other. There is a concerning trend of anti-suit injunctions and anti-suit injunctions, which demonstrate that we are perhaps not being true to the principle of comity of courts. As members of the judiciary, we should be more open to factor in principles and standards laid down by courts of competent jurisdictions in other countries to ensure parity in justice delivery system and predictability of litigation. Until governments negotiate a TRIPS 2 agreement that factors in the balance of rights in cross-border disputes, forums such as this masterclass and organizations like WIPO can go a long way in facilitating this exchange of ideas and formulation of best practices. May this masterclass be a source of inspiration, collaboration, and enlightenment, paving the way for a future where intellectual property thrives and is protected seamlessly across borders in harmony with the dynamics of a new digital ecosystem. Thank you, and Jai Hind.
Thank you, sir, for sharing your valuable insights on the subject. I request Ms. Yunju Min, Director of the WIPO Judicial Institute, to kindly give the introduction to the WIPO Masterclass.
Justice Khanna, Justice Manmohan, Justice Singh, Justice Chawla, Special Secretary Kumaran. Distinguished judges, dear friends, dear colleagues, on behalf of the World Intellectual Property Organization, it is a great honor and privilege to organize the 2024 WIPO Masterclass on Intellectual Property Adjudication, Judicial Perspectives, jointly with the High Court of Delhi. We're excited that the Masterclass is taking place in India this year, as a journey of India's IP and innovation ecosystem makes the country a particularly apt venue. India is now the world's third largest trademark filer, the sixth largest patent filer, and the 11th largest design filer. The High Court of Delhi itself exemplifies innovation by establishing the IP division. The success of the IP division is inspiring other high courts in India to follow suit and serving as a model for countries outside India. Indeed, the role of the High Court of Delhi in the IP and innovation ecosystem of India is exemplar of the role of the judiciary in realizing the instrumental purpose of intellectual property. As a robust IP legal framework must be coupled with a judicial system that provides for predictability for market structures and that appropriately calibrates the broad balance of public considerations envisaged in the IP system. At the same time, the current rapid pace of technological developments is unprecedented, and courts are increasingly placed on the front line to provide clear and effective answers for questions that have not yet received a legislative policy response and are establishing important precedents that shape IP laws, affect market participants, and result in broader social, economic, scientific, and ethical consequences. Globalization is leading the homogenization of legal problems, and courts across the world are facing similar challenges. This requires that the judicial structures respond effectively to the local needs of each country, while at the same time working harmoniously across territorial boundaries to engage with the demands of an interconnected and increasing digital world. So, leveraging the distinct position that WIPO has as a multilateral global institution, the WIPO Judicial Institute serves as a convener of a worldwide community of judges, currently comprising some 3,000 judges from over 165 countries, to empower judiciaries to fulfill their role. The masterclass, bringing together in this edition some 36 judges from 21 countries, aims to raise awareness of the common challenges and the solutions adopted in each jurisdiction, to contribute to coherence and mutual respect between distinct legal systems and judicial structures across the different countries. Cross-pollination of judicial approaches helps not only when the solutions and reasonings of others are adopted, but also when courts depart from the approaches of foreign courts. There are important reasons why the solutions in one country may not be appropriate in another. Considering and articulating the differences that mandate the adoption of a different solution is particularly valuable in building rationality, cogency, and legitimacy in the ultimate decision of the court. So we are deeply honored and privileged to be strengthening the ties between WIPO and the High Court of Delhi through the joint organization of the masterclass. Justice Pratibha Singh, you have WIPO's institutional and my personal gratitude for this collaboration. I would also like to thank Judge Rian Calden, who represents the judicial community as a chair of the WIPO Advisory Board of Judges, the faculty members, and all the participants that have come from distant places to join us here. I hope the next 3 days, which will be held under Chatham House rules, will yield not only exciting and productive exchanges, but also lasting friendships around intellectual property. Thank you very much.
Thank you, ma'am, for sharing with us the background and the purpose of the WIPO Masterclass. Our guest of honor, Dr. S. Jayashankar, Honorable Minister for External Affairs, Government of India, could not be present here personally because of his prior official commitments. He shall deliver his e-address through his video recorded message.
Honorable Justices, legal luminaries from around the world, ladies and gentlemen, Namaskar. I'm delighted to deliver my remarks at the inaugural session of this important event. I was hoping to participate in person, but my prior commitments have kept me away. I'm happy to note that the World Intellectual Property Organization, WIPO, is collaborating with the Honorable High Court of Delhi in holding these master class sessions in India. Our engagement with international bodies such as WIPO underscore commitment to global cooperation in the realm of intellectual property. By participating in various treaties administered by the WIPO and aligning its laws with international standards, India has positioned itself as a key player in the field of intellectual property, recognizing its pivotal role in driving innovation, economic growth, and cultural development. Intellectual property, IP, stands as a cornerstone of human ingenuity, encapsulating the fruits of creativity and innovation within intangible legal rights. In our modern era, intellectual property rights, IPR, have assumed paramount importance in global trade practices and the sustenance of livelihoods worldwide. These rights serve not only to acknowledge and reward creators and inventors, but also to stimulate ongoing innovation, thus fostering societal and economic advancement. As you are all aware, the introduction of National Intellectual Rights Policy in 2016 represents a landmark initiative aimed at fostering creativity and innovation within India. This policy delineates a comprehensive roadmap for the future of intellectual property rights in the country, emphasizing the importance of awareness, commercialization, modernization, and human capital development in the field of intellectual property. Recent developments within India's academic sphere signal a growing interest in intellectual property law, with leading universities offering specialized courses and establishing chairs dedicated to this field. The participation of Indian academics in international fellowships and the inclusion of intellectual property law surveys in legal publications further underscore our commitment to nurture expertise and scholarship in this vital area. The Government of India has been fostering creativity and innovation through several national initiatives such as Make in India, Digital India, Startup India, the Atal Tinkering Labs, and the Atal Incubation Centers, the WISE, that is Women in Science and Engineering programs, and NIPAM, that is National Intellectual Property Awareness Mission. India's Patent Office runs NIPAM for IPR awareness, with sessions already held in 4,000 educational institutions, reaching as many as 2 million students. The results of all these initiatives are also very clear. India has been on a rising trajectory over the past several years, as reflected in WIPO's Global Innovation Index. It has risen from a rank of 81 in 2015 to 40 in 2023, and is now among the top innovation economies of the world, both in terms of income category and the region. In fact, innovation has been at the forefront of our battle against the unprecedented crisis created by the pandemic. During India's G20 presidency last year, we deliberated on structural issues that today are at the heart of the predicament of the Global South. Key among them are various concentrations created by the last 3 to 4 decades of globalization for a variety of reasons that range from scale, subsidies, technology, human resources, and strategic choices. The Global South was largely reduced to being a consumer rather than a producer. India's response to this situation is articulated in the goal of Atmanirbhar Bharat, that is, a self-reliant India. At its core is the Make in India initiative, one that not only focuses on our own needs, but those of others as well, driven by a strong commitment to make it easier to do business in India. Indeed, the mindset itself is undergoing a transformation, a new India that creates its own 5G stack, which invents and mass produces its COVID vaccine, and which lands near the South Pole of the moon. The talents and skills of our youth are by now an intrinsic element of global innovation. Sharing his vision for the future, Prime Minister Narendra Modi, while speaking in the Rajya Sabha last month, said that he foresaw that the number of patents in the next 5 years, surpassing the total number of patents filed in the past 7 decades. Already, to ensure that our Patents Office keeps up with this unleashing innovation energy of the country, we have decided to triple the number of patent examiners, and nearly half of the newly recruited personnel have already joined. It is equally important that our judicial system keeps pace with these increased numbers and scales its own capacity to provide speedy and efficient patent adjudication. India's objective is to promote inclusive, balanced, and sustainable IP policies that support innovation, creativity, and economic development. So, in conclusion, let me underline here the importance of masterclass sessions for us. It is vital to ensure that innovators are able to file and prosecute patent applications more efficiently and cost effectively with more predictable outcomes. The Government of India has an interest to support having an efficient patent adjudication system domestically and globally as part of our efforts to ensure better global access for your talent and stronger protection for our businesses. I'm sure that discussions over the next few days will provide a comprehensive and practical overview of different stages of patent litigation and foster a deeper understanding of evolving patent jurisprudence. I thank you for your attention.
We thank our guest of honor for the enlightening address. I now request Mr. P. Kumaran, Special Secretary, Economic Relations and Development Partnership Administration, Ministry of External Affairs, to kindly deliver the special address. Please, sir.
Honorable Justice Sanjeev Khanna, esteemed judges on the dais, Ms. Yunju Min, Director, WIPO Judicial Institute, other dignitaries, ladies and gentlemen, good morning and namaskar. It is a privilege to be part of the inaugural session of this important masterclass, which is a direct outcome of the sustained collaboration between the Delhi High Court and the WIPO over the past couple of years. My congratulations to Honorable Justice Pratibha Singh and the rest of the organizing team for bringing this to fruition. The Honorable External Affairs Minister, in his virtual address, has already listed the giant strides that have taken place in India in innovation and IP, as evident in several of our flagship national programs. Over the past 5 years, the Government of India has taken positive steps to strengthen its IPR regime, including efforts to modernize its IP offices, increase manpower, use IT and technology in e-filing of applications, deliver certificates of grants and registrations in digital format, reduce the number of trademark forms, use video conferencing for hearing of IP applications, created expedited examination procedures, and spread awareness on IP issues. The role of the digital economy is becoming increasingly important globally as it offers a range of opportunities for economic growth, job creation, and also innovation. India's digital economy grew 2.4 times faster than the Indian economy itself, with strong forward and backward linkages. India is today the third largest digitized country in the world, only behind the United States and China, going by aggregate levels of digitization. The total size of the digital economy in India is currently estimated at over $300 billion. This is projected to grow to $1 trillion by 2030. India's startup ecosystem is one of the fastest growing in the world, with over 120,000 startups and 113 unicorns. Notably, this surge is linked to the rising digital demand in areas beyond the metros, growing digitization of traditional businesses, and the explosive growth of the startup ecosystem and the success of India Stack. India's approach to digital transformation is guided by a commitment to digital public infrastructure, an approach that has received global recognition from a number of international organizations. But digitalization in India is not limited to financial inclusion alone and is widely used for streamlining welfare delivery and improving access to public services. A comprehensive governance framework that provides for transparent, predictable, and reliable IPR protection is a necessary condition to foster a culture of innovation, as it encourages entrepreneurs to invest in R&D with the assurance that their creations are safeguarded and they can reap the benefits of their innovations. But digital innovation brings challenges along with these opportunities for intellectual property rights. Key challenges include issues like online piracy, copyright infringement, and cross-border disputes due to the global nature of digital platforms. On the other hand, opportunities arise from the ability to reach wider audiences, leverage data analytics, and create new forms of content. India's strategic approach towards navigating intellectual property challenges and opportunities is therefore multifaceted, involving legislative reforms, technological advancements, and broad-based educational initiatives. These efforts not only enhance India's position in the global digital economy, but also pave the way for sustainable growth and innovation in the intellectual property domain. As the Honorable Minister mentioned, the Government of India launched the National IPR Policy 2016 under the tagline, Creative India, Innovative India. The Cell for IPR Promotion and Management of the Department of Promotion of Industry and Internal Trade, DPIIT, is tasked with implementing IPR policy. DPIIT has also partnered with FICCI to launch an IPR enforcement toolkit to help track and handle IP crimes, counterfeiting, and privacy. The Ministry of Electronics and Information Technology, MeitY, has taken a number of steps to promote IPRs in the digital domain. These include the establishment of a Center of Excellence in Intellectual Property, providing financial support to startups and MSMEs for international patent filing, and generating IPR awareness through financial support to industry bodies and academia. With the recent advances in global mega platforms and generative AI tools, which can create new content in various forms, we are required to address a number of issues and challenges related to ownership and inventorship, especially for AI-generated content, decide whether a sui generis IPR system should be considered for AI-generated inventions instead of tweaking the existing system, how to deal with deep fakes and bias in AI applications, assessing the IP value of proprietary data, complexities in the establishment of copyright ownership in digital media, territoriality of IPRs, and the constant need for capacity building to adjudicate disputes relating to new and emerging technologies. The masterclass indeed seeks to discuss many of these issues. India also engages with other countries through regular dialogues on IPR issues. The US-India Trade Policy Forums, Working Group on Intellectual Property, and the India-EU IPR dialogue between the European Commission and DPIIT are two such prominent mechanisms. In some new bilateral and regional FTAs, and in some specialized digital economy partnership agreements, IP protection in the digital domain has extended beyond the standards prescribed by TRIPS of WTO. India is yet to take a position on such agreements. While we are on the right path, more work is required. I am confident that detailed discussions during the course of this masterclass will provide an opportunity to delve deeper into the various legal and administrative issues relating to IPRs for the digital economy. This will hopefully result in a better and shared understanding of the legal challenges arising from fast-paced developments across the globe, ultimately leading to a more comprehensive and effective patent protection framework and enforcement infrastructure. I convey my best wishes for useful and productive discussions in this masterclass and look forward to continued collaboration between WIPO and India for more such events. Thank you very much. Namaskar.
Thank you, sir. We are honored to have had the opportunity to hear from you the latest developments in the field of IPR. May I now request our Chief Guest, Honorable Justice Sanjeev Khanna, to kindly address this august gathering.
Mr. Justice Manmohan, Acting Chief Justice, Ms. Unjo Min, Director, WIPO Judicial Institute, Mr. P. Kumarkam, Special Secretary, Ministry of External Affairs, Ms. Justice Pratibha Singh, Mr. Justice Naveen Chawla, judges from Delhi High Court and other high courts, and judges who have come all the way from the world. Esteemed participants and guests, namaste and good morning. The Sanskrit phrase, Vasudeva Kutumbakam, the world is one family, is often quoted and accepted. But today, the world has surfaced in a new avatar, the virtual world, a world without territorial borders. Physical presence and movement is not at all required. Coupled and fused with the economic and commercial interdependence between nation-states, the New World Order challenges strict allegiance to territorial sovereignty and the Mozambique rule. In an interconnected world, the significance of international rule of law and rules-based order cannot be overstated. Rules-based systems ensure that the interactions respect and abide by agreed-upon rights and obligations. Universality requires as well as cultivates fairness, harmony, and mutual respects, discourages violation of rights, and encourages resolution of cross-border issues. Comity or amity denotes practice among different jurisdictions to mutually recognize legislative, executive, and judicial acts. We have recognized and accepted need for comity, including judicial comity. Judicial comity means cooperation of various judicial systems around the world to ensure uniform application of laws to the extent best possible. Cross-border trade and commerce demands impartial rules, efficient adjudication, mutual recognition, and enforceable regulations. Establishing an international rule-based order involves two main challenges. First, it requires crafting a legal framework defining rights and obligations. Secondly, it involves developing a robust mechanism for resolving disputes and addressing violations. International rule-based law comprises of governing arrangements through treaties, agreements, and international institutions cutting across various realms. I would include universally recognized and accepted principles of private and international laws. Such a framework encourages cooperation, stability, and predictability. The second aspect of rule of law lies in delivering fair and just decisions which are free from external elements, bias, and prejudice. Justice can be described as existence of rules that provide right to fair and a just decision, a procedure which ensures and provides equal and a fair chance of winning against your opponent. It took nearly 5 decades long transition from General Agreement on Tariffs and Trades to World Trade Organization from 1944 to 1995. However, the transition and complexities involved with the intellectual property rights had seen agreements as early in the Paris Convention in 1883 and Berne Convention in 1886. The 1995 Agreement on Trade-Related Aspects of Intellectual Property Rights has played a crucial role in this evolution. WIPO has a unique role in supporting creation of a balanced international intellectual rights regime. Established in 1967 by the WIPO Convention, it is a specialized agency of the United Nations. WIPO comprises of General Assembly, a secretariat with membership spanning 193 member states. As a global leader in IP protection, WIPO employs self-regulatory approaches based upon expertise-driven systems. Under its administrative role, WIPO manages 3 key systems of international intellectual property protection. A unique aspect of the system is its ability to allow applicants to seek protection in multiple countries through a single application. As a part of capacity building role, the WIPO Judicial Institute aims to enhance the capacity and expertise of judges around the world in handling IP disputes. Through the capacity building, resource development and maintenance of WIPO lex database, it provides effective support to the judiciary. WIPO fulfills its education and awareness role through WIPO Academy initiative. In last few years, they have trained about 270,000 individuals globally and has expanded its offering to include practical courses tailored to the needs of startup and exporters. But to me, the most important role which WIPO provides and fulfills is a quasi-judicial role in the form of arbitration and mediation center. In an era marked by a rise of cross-border trade and IP exploitation, disputes are likely to span multiple jurisdictions. The center is one of its kind global provider for specialized ADR services for IP disputes. It offers mediation, arbitration, expedited arbitration, and expert determination procedures. It ensures judicial neutrality as it provides a neutral forum for dispute resolution preferred over domestic courts. WIPO's Center for ADR rules are neutral to the law, language, and culture of the parties, giving it a clear advantage over litigation. It allows multiple issues and rights arising under different jurisdictions to be addressed in a single process. The domain name dispute resolution, the WIPO Center is highly sought after globally. It supervises proceedings under the Uniform Domain Name Dispute Resolution Policy and other relevant policies. The third aspect which I've noticed is the WIPO data indicates significant surge in utilization of global IP system. In last half decade, there has been notably 40% increase in the global IP applications spanning patents, trademarks, and designs. However, it is not only the growth of IP, innovation, and creativity, the engines empowering such growth are also changing. A decade ago, Europe and North America accounted for half of the IP filings globally. Today, the portion has dwindled to 2 out of 10, with remaining 8 originating from the Global South. Global South is emerging as a powerhouse of ideas and innovations. In a span of just a decade, India has witnessed a monumental leap in the grant of patents. To put it in perspective, in 2013-14, a total of 4,227 patents were granted, whereas in the year 2023-24, the highest number of 41,010 patents were granting, an increase of nearly 10 times. This remarkable surge underscores the profound trend in growth of innovation and research and development within India. There are new challenges emerging in the form of artificial intelligence tools, biotechnologies, nanotechnologies. Distinction between physical and digital innovations are fading. The master class of IP adjudication marks a significant milestone in offering a distinctive opportunity to exchange knowledge, provide invaluable training, and bolster resource capacities within the realm of IP administration. What makes this equation truly remarkable is the collaborative effort between WIPO and the Delhi High Court. Today amidst us are judges representing 24 jurisdictions converging for the master class unlike any other. Together, let us seize this moment to collaborate, innovate, and shape the future landscape of IP administration with our collective wisdom and shared expertise. Thank you, and Jai Hind.
Thank you, sir, for initiating this 3-day 2024 WIPO Masterclass on Intellectual Property Adjudication. Your words of wisdom have been inspirational and have added great value to today's proceedings. Your presence has made this event special, sir. May I now request Honorable Justice Naveen Chawla, Judge High Court of Delhi, to kindly deliver the vote of thanks.
Good morning, all. It is my pleasure and honor to deliver this vote of thanks today. This function to inaugurate the Masterclass on Intellectual Property Adjudication, Judicial Perspective, has been honored by the august presence of the Chief Guest, Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India. Sir, you are highlighting the fact of the universal international laws, needs and ambit has been well taken and recognized. Your kind words and insightful thoughts shared with us today will inspire us to achieve even more in future. We are also thankful to Dr. S. Jaishankar, Honorable Minister, Ministry of External Affairs, for taking out time from his busy schedule. Sir, though you could not personally be present in this function, but your message on the steps taken by the government to strengthen country's IP initiative and promote innovation are delivered home. We are also thankful to Mr. P. Kumaran, Special Secretary, Economic Relations and Development Partnership Administration, Ministry of External Affairs, for his presence today in this function and sharing the steps taken by the government to address the issues arising out of digital and AI world. Our special thanks goes to Ms. Yuju Min, Director, WIPO Judicial Institute, for her introduction to the WIPO Masterclass and how it aims to bring about an amalgam of different judicial systems and learn from each other. I myself, as a student in this class, am looking forward to learn from the international experience that the esteemed presenters are going to share with us over the next 2 days. In every function, there has to be a foot soldier and there has to be a leader. In the present case, the foot soldier is Honorable Ms. Justice Pratibha M. Singh, who has tirelessly worked first to bring the WIPO Masterclass to India and then to organize the present function and what is to follow over the next 2 days. The leader, of course, is the Acting Chief Justice, Honorable Mr. Justice Manmohan, who leads the path and always encourages an endeavor made by any one of us to enhance our knowledge and skills by organizing such functions. Sir, you have set the tone by rightly highlighting the trans-border implications that IP disputes now have. We thank you for all the encouragement that you always give us. My special thanks also goes to my brother and sister judges who have taken trouble to reach the venue early in the morning on a working day, knowing fully well that they have a long day ahead in court. My thanks and gratitude also goes to the other participants and especially to the foreign delegates, my brothers and sister judges from other courts who would be participating in the masterclass, Mr. Chetan Sharma, the learned ASG who was there, and all present today. Have a good day. Thank you all.
With this, we come to the close of the inaugural. Please join us for high tea on the right side of the hall.